Welcome again very much to this wonderful event. We're very grateful to all the organizations that facilitate that we can do this today. It's also really great to be doing this in the context of the school, because this is something which really requires an interdisciplinary perspective, and that's also what we try today, but also like an outreach perspective. So what you hear today is also, as already mentioned, business perspectives, perspectives from civil society, and so on. And again, we'd like to record the event today, so please be aware of that, and if you would not like to be on the record, then please let us know, and we can look into that as well. So, for the first panel, our goal of the discussion is to actually discuss the approach, the regulatory approach as it emerged for a discipline which is moving very fast, as you all know. It seems like the AI hype is unstoppable, although there's already 7 decades of research. Researchers are still discussing, what is it actually, what are we talking about now? The regulator, the European Union, tries to come up with a definition to something which is, again, scientifically contested. And it's also really, really interesting to look at the history of the AI Act. So in 2018, the European Union started to prepare a regulatory approach, or maybe more like a broad AI AI strategy, by bringing together experts looking primarily at ethical challenges. And they came up with reports and guidelines following 7 different types of principles, such as transparency, human-centeredness, control, etc. And all of these guidelines, there have been numerous of them. Eventually, in 2021, together also with thinking about how should this be funded, how should this be, stimulated in the European Union. In 2021, eventually in April, led to the presentation of a first proposal for what is now the AI Act. It's also kind of strange. In the past, European Union law used to be much more boring. We were talking about directives and regulations, but these days we need to be more hip, so we don't need to talk about acts. So that was presented in April 2021, and now 3 years later, roughly, it seems that we are at the end of this journey, which started in 2018, but still at the same time, last week I had the opportunity to be in Brussels to talk to a member of the European Parliament. And it's an interesting time for all of this to come to an end. And why is that? Because, as you might know, in May or early spring, there will be votes for the European Parliament. And now the feeling is in Brussels at the moment that lots of things which are ongoing, where the debates have been held over the last legislative period, they have to come to an end, right? And when you think about the area of artificial intelligence, that's particularly interesting. So some of the developments which really keep us very, very busy these days, like generative AI, foundation models, general purpose AI, however we would like to call it, or the spread of biometric surveillance and facial recognition, all of these are topics which are moving very, very fast, and at the same time, the European Union tries to bring this to an end and bring this to a close. There has been a marathon negotiation and a trilogue with the European Parliament, the European Commission, and the Council, so the ministers of the individual member states working together, which led to a political agreement in December. But over the last 2 months, it seemed that nobody really was 100% sure what they actually agreed upon, because there were lots of technical meetings up until last Friday, where on a technical level, on a sort of like an ambassadors from the member states level, there has now been really an agreement on what should be the final text. But that does not mean that the journey is over. There's lots of things which still need to be worked out by the Commission. There's lots of things which still need to be worked out by oversight bodies. There's going to be probably different flavors of interpreting the text. So there's lots and lots to discuss. And I'm very happy that we have really an expert panel to kick off this discussion now. But I also like to make this long introduction saying they have really, really a complicated task today. And everything that we are going to discuss right now is very topical and very timely, but at the same time moving really, really fast. So allow me to introduce the panelists of today. We're very happy here to my right. We have Bart Beima from the AI Hub Noord Nederland, which is part of the Dutch AI Coalition. True. So Bart will take the floor as a second speaker, sharing his insights from more of a business-oriented perspective. Right next to him, Professor Frederik Zuiderveen Borgesius, who works at the Radboud University as professor of ICT and law. He's also a national and internationally very well recognized expert on the subject, who has followed the dossier from the start, but at the same time has also, is one of those people like me who try to desperately keep up with it. And I'm really curious, Frederik, how you're going to kick off our discussion today. Then we have Tim van den Belt, who is a strategy advisor working on AI supervision at the Dutch Authority for Digital Infrastructure, which some of you might know as the RDI. Tim will share a couple of perspectives as the third speaker, talking about it from a regulatory perspective, from a supervisory perspective. What is the Dutch approach there, and maybe how does it compare to other member states? And then last but certainly not least, I'm very, very grateful that on a very spontaneous note, Michael Veale could join us. He's an associate professor in digital rights and regulation and vice dean of education innovation at the University College London. Thank you for joining us. Michael is also a very well recognized expert on the issue, working on automated decision-making algorithms and AI with an interdisciplinary background for how long?
10 years or so, maybe.
10 years. So we have a lot of expertise, but again, the task is complicated. So the format of the panel is going to be each of the speakers gets around 10 minutes to make a couple of points on what strikes them and where the text is standing now, what are the challenges going forward, and then we'll open up the floor. We have the students again roaming around with microphones so that we get an interactive discussion with you. Now, Frederik.
Thank you.
Yeah.
Yeah, I have quite some experience with law and technology, but this is the most complicated statute that I've ever seen in my whole career. And it's long too. This is it, and this is not complete. I left out all the recitals, which would have added a third of the on the pile of paper. Recitals are kind of introduction that I generally advise you to skip when you read EU regulations. So complicated stuff, and I'm still studying and trying to understand it. And I'm going to make 2 points, one broad point and one detailed point that illustrates some bigger things. The broad point is this will probably be adopted. So the Parliament still has to officially adopt it, but apart from small tweaks by the in-house lawyers at the EU, this will probably be the text. So, legal scholars like Michael and I, we like when things go completely well, we tend not to write papers. When there's problems, we tend to write papers. So we're going to have a lot of papers saying this is wrong, this is complicated, they should have thought better about this, etc. And I'm completely guilty about that too. Meanwhile, we also have to accept this is ready now. So for society, it's perhaps more productive if we just try to make the best of it, because we can't influence this text anymore. Nevertheless, if you have inspiration, there's the Commission still has to adopt around 20 kind of sub-regulations. There's the member states have some room to adopt additional regulations. There's going to be an AI board that can adopt guidelines. But I'll leave that topic to Michael. Much is going to go happen in standardization bodies. So if you have actual serious points, you can always blog or write papers in English. For instance, this unclear bit in the AI definition, it would be good if the European Commission blah, blah, blah. Such input can still have influence. But my main point is, regardless of completely fair criticism that we can have, let's try to make the best of it now. And then a much more detailed point that illustrates the difficult policy choices that EU had to deal with. Imagine that you're a company that uses AI, for instance, for selecting job applicants. You get thousands of letters, and without AI, your HR people can probably read the first 50 with some focus. If you find 5 good candidates, then you can invite them, and the other 950 probably get never looked at, or at least not in detail. That feels a bit unfortunate and unfair towards those 950 people. So there are fairness arguments to say, what if we have a computer or an AI system do a pre-selection of the best 50 job applicants, and the HR people can look at those? Completely understandable for the company, but perhaps the company has heard the news or seen newspapers the past few years, so thinks, oh, but I don't want accidentally to discriminate against gays or Muslims or people with a Moroccan background. So the company wants, a well-meaning company probably wants to audit the AI system that it licensed to use. But to see whether you accidentally, whether your computer system accidentally puts all the letters of people, of all the Muslims aside, you need to know who of your job applicants is Muslim and who did you hire in the end. Now, the GDPR, for very good reasons, prohibits companies of touching these kinds of data. So companies, luckily, are not allowed to make databases with homosexuals or Muslims or Protestants or about their sexual preferences, about their medical files, etc. With a list of exceptions, of course. Obviously, hospitals can do something with their medical data, etc. But there's no exception for auditing AI systems. The AI Act introduces such an exception, but this illustrates that there are very strong arguments not to introduce such an exception, namely who is comfortable with big tech building databases with homosexuals or Muslims, etc. On the other hand, you can't audit your AI systems without such databases. In the end, the European Commission decided, after weighing the arguments apparently, okay, an exception is better, already in the original proposal, and in the final proposal, the exception is still there. Difficult choice, but a fair policy choice, and the Parliament added a lot of safeguards, namely heavy privacy by design and security requirements, etc. And it's only possible if you can't use synthetic data or anonymous data. So this illustrates that part of the regulation have become better, especially after input from the European Parliament, but it also illustrates the incredibly difficult choices that the EU had to make. Yeah. Oh, and lastly, I want to say, and of course I'm going to be guilty again too, a lot of grumpiness about what should be better in the text. We also have to realize it's hard for Brussels. They don't adopt any laws in the US. They do some in China, but we tend to have different values in society. So it's not that Brussels can look at other regions and say, we're going to copy that. They're by and large well-meaning. It's technocratic stuff, large-scale impact assessments, etc. And of course they mess up every now and then, but we have it much easier, namely wait for a proposal and start shooting at it. Yeah, I'll leave it at that. Complicated stuff, but let's make the best of it.
Yeah, but I hear you also saying a bit, it's probably impossible to make the perfect law, but what we get is better than nothing, right?
Yeah, I think it's probably better than nothing. Regardless, we have it now. We almost have it. So,
okay. Okay. So rather deterministic about that. Bart, you are working a lot with governmental institutions, but also a lot with businesses, right? Yeah, and also here in the region, in the north of the Netherlands, you have a broad network, so you know what people who are thinking about innovation from that angle, what they are caring about, what they're thinking about. What is your perspective on what is happening in this area?
Well, it's quite difficult to understand for especially small and medium enterprises. Yeah. And I don't know if there's someone who's working here at a small or medium enterprise. One person, two.
A couple.
Well, I think that says enough.
Yeah.
It's difficult to reach them and to have this conversation. Because it's difficult, it's abstract, it can give a lot of opportunities, but how to get those opportunities, that's difficult.
Yeah.
And who can I call to help me, for example?
Yeah. I'm just seeing they also brought up your slides. So is it? Can they call you, for instance? Can they call AI after this? Or where do you get the information from?
They can always call me, and then I call you. Now, well, that's a good question, because we're also with the AI Hub working on this ecosystem in the northern part of the Netherlands to help small and medium enterprises to get this information.
Yeah.
So I think with the university and other institutions here, we can help those people.
All right.
So they can call me.
Yeah. And is there a particular area where you see chances, or where the partners that you're working with, where they see a lot of chances?
There are chances, and maybe I can share something with my presentation.
Yeah, go ahead.
All right.
Clicker should work.
All right. A nice slide. My name is Bart. I'm working for the AI Hub North Netherlands, which is a part of the National AI Coalition. And I think nowadays we are in the perfect storm. And that's not negative, because there are challenges. We have to overcome the challenges about sustainability. There's the energy transition. We have to do something with digitalization. There are not enough people. Resources are difficult. And in the same time, we have to improve our productivity. So that are a few challenges for the industry, which I am mostly representing. And on the other hand, there are the acts. So good luck if you're having a company. But there's also a lighthouse. And I think this is the perfect time to embrace those acts. And it all has to do with this. China, Europe, America. It's difficult to be competitive with those big tech companies. But there are chances, I think, especially for production companies. If, for example, you have some equipment from different manufacturers, you can't reach the data right now, and with this Data Act, you can reach them. How to reach them, that's also difficult, but it gives some opportunities. So this whole AI Act and Data Act, and maybe also the CHIP Act, which is also coming, it's definitely not boring. It can help us in the transition from Industry 4.0 to 5.0. It can really help us. So it's a chance. Let's jump into it.
All right. So you're on the optimistic side, but what I also see from you is a challenge relating to, how those rules would relate into something which is tangible for the people that you're working with, or the businesses you're working with.
Exactly. Yeah.
All right, so let's then move on to a regulatory perspective, and I'm particularly interested if you can also. First of all, I'm interested in what are the challenges from a governmental perspective going forward in addressing this, and how do you address this? Where do you see complexities, but also where do you see maybe opportunities in a positive role to maybe help Bart and his peers?
Yeah. Okay. Can I get the presenter? Yeah, okay. Thank you.
Oskar, sorry. There it is.
Yeah. Okay. Thank you. First of all, the reason why I'm here is to achieve hopefully two things. One of them is to make clear what we do as regulators and try to take the concerns away that there are, or if there are suggestions or still concerns. The second thing I try to achieve here is to have a discussion about it. Because we do not know everything. We try to do our best with, as Frederik said, what we have currently. But yeah, we try our best, but we do not know as much as society itself. So please, at the discussion, if you have a concern, let it know. First, I'll try to tell a bit of what we do, to have a context of what we do, at least in the Netherlands and a bit of in Europe. Secondly, about some key elements, at least for us, about the AI Act. And thirdly, I want to address the risk-based approach of the AI Act, plus what I'll explain later. And at the end, the challenges and uncertainties we see so far. First of what we do is, of course, the AI Act. We need to prepare for it. So in the national governance, we have a working group, currently chaired by us with all the supervisory bodies in the Netherlands, and we also chair the working group of European competent authorities to try to share the knowledge and the challenges we see in each state, and to try to form a governance, at least in the Netherlands, and perhaps a more shared type of governance European-wide. We also try to create a AI lab to gather knowledge so we can use the knowledge for all the governmental institutes, especially the supervisory institutes, to have knowledge about AI, and so we can confront the market about the things they say, but perhaps we do not understand, but we try to leave out the we do not understand. And of course, use AI. We are simply starting by, for example, a chatbot to write a piece for me, or have a vector database for those who know, to get a signal about the parliamentary documents, so we know what is going on when relevant. And we have, since half a year, a collaboration with the EU and UNESCO to address the framework of the AI Act and to see what can be shared and done to implement it as efficiently and effectively as possible. And I believe perhaps in a month, the UNESCO will publish a report about the global governance or global legal frameworks currently present. And we also work with the AI 36 group. It's an informal group of the National Intelligence Agency and the National Cybersecurity Center.
And you guys.
Yeah, correct, sorry, yeah. And regulatory sandboxes together with the ministry. That out of the way. Next, the key elements, of course, as stated, product regulation. So it means certification and self-assessment by standards. And the topic said the legal, for the fundamental rights, but to make it a bit sharper, it's also safety and health. And that is important because what we currently see as regulators is the intended purpose is important. You certify or do a self-assessment for an intended purpose. So what we currently look at as regulators is that the context of where the AI is operating is important. The context of where you want to certify it for is relevant. So what we currently see is that we have every regulator in the Netherlands relevant, being a regulator also within the AI Act. So every regulator has the expertise, the knowledge of the sector where the AI is applied in. So we can try to regulate as best as we can. At the same time, we try to utilize the global expertise, the relevant expertise across all sectors. An example is what we try to say is cybersecurity, for example, is important within AI products. So we try to share the knowledge with the other institutes who do not have the same level of knowledge. At the same time, we also see a trend that it might reshape the national collaborative framework between regulators, because everything is more digital, the digitalization. We see that across the regulatory bodies that more is woven together. So that might also ask something else of the regulators besides the AI Act. And risk-based, which I will get in a minute. This is an example of how we look at the discussions we currently have with all the other regulatory bodies. In 2 weeks, we try to define this image as best as we can. Sorry for it being Dutch, but I thought it might be helpful.
I think it's very helpful. And people are already taking pictures. So.
On the left, you see all the regulators we think are most relevant. At the bottom, you see the themes as listed in Annex 3. And you see a part of Annex 2, which is other product legislation, and how we can utilize the best expertise of every regulator. Risk-based and risk-based. The AI Act is already risk-based, but at the same time, we regulators see that we are trying to operate in a risk-based way. So that isn't just that the AI Act is risk-based. And what I mean by that is we try to address the concerns or the public values which are threatened in the most efficient and most effective way. It can be that the standards are the best way to address those issues, and it is a primary part of the AI Act. The question is, is that the most efficient and effective way for a regulator? That is our most important task, to look at it. We have to deal within the framework, but we try to do our best within the scope of what we can. And as I mentioned earlier, the context matters. We have a different toolbox every time we go into the market. Sometimes we need to give a fine to a company which is deliberately frustrating the market and doing things we do not want. But at the same time, if someone is unknowingly doing something wrong, but wants to do something good, it might help to go into the discussion. So the approach is different in every context and also in every sector. So that's why we also do the sectoral approach with all the authorities. Recently, we did a collaboration with the University of Utrecht Data School, and they are going to hopefully publish soon a performance review guideline or tool to help markets or companies, entities, after they use or produce their products. Because it isn't just the start, it's also thereafter. And it's a different approach than, for example, the standards which are named to try to get the best out of the AI Act. And at the same time, we try to do a uniform approach. So we try to approach every sector the same, but at the same time we need to have a tailored approach for different sectors, because every sector is different. Some are more mature than others, some are more less mature. But we try to do the same. So it's a difficult balance to keep, and one of the challenges we have as the group of regulators, which we will try to figure out. Challenges and uncertainties, of course, which authority or authorities, probably, at least that's the current advice we have, are going to be appointed. It's up to the ministry, of course, but we advise currently to have it broad and utilize the expertise for every regulator. Standards, of course, they are currently developed, and for example, what we see is that most standards are currently horizontal, so across different sectors, but we also see more vertical, perhaps, being developed. And, not unimportant, it's also a part of the political game. As mentioned earlier, the global political game. The EU governance, it's a bit clear, but still they need to have all the people in place, and that might take a while. At the same time, we need to move forward. So how are we going to do that? For example, through the EU working group or otherwise? Interpretation guidance, easy, we do not know yet. We are also trying to figure it out. It's just published, so a challenge. Notified bodies, meaning the certifying bodies, they need to be appointed for the intended purposes. So, yeah, it's, let's say, a tricky game. Regulatory sandboxes, as in Bart already addressed, there's a lot of uncertainty, and it's a tool to help entities in the market to understand what they can and cannot do, simply put. Outside the scope of the AI, but we do think it's important, is cybersecurity. We see a large threat in cybersecurity because of AI. Cybersecurity is likely part of the AI, but it is larger than that. It's also what we say is the AI is just a piece of the puzzle. So it is a part of what we need to have in society. And as mentioned, digital autonomy, so I'm not going to address it, and the rapid developments. We also need to keep up with the trends and the status quo. Yeah. And what I hope later on is especially discussion, so feel free to contact.
Yeah, thank you very much. I think it was a very interesting presentation. If I may, I would have one follow-up question, because if I understood correctly, the enforcement bit, so the defining capacity in the Netherlands has been decided to centralize with the Data Protection Authority, right?
Formally, yes, but we are working together with the authority, the DPA. Together we are leading the working group to try to find a governance for an enforcement. Because what we, as I mentioned, what we see is that using the sector-based approach might be best. Mm-hmm. So it probably won't be a single, but 2, 3, 4, 5 bodies which are most appropriate for the Netherlands.
But from what you see, so different member states at the moment are trying to figure out differently for how that works with their administrative cultures. That's what I get from that.
Yeah, correct. Spain, for example, has a single authority appointed for the AI Act, but we also, as I mentioned, in the European working group, we shared our knowledge, and they are going to reevaluate, is this indeed the best approach? Because it might be a good approach for Spain. Each member state is different. They have a different amount of regulators. We have more than some member states, others have less. If they already have one or two, it's better to leave it at one. Yeah.
And then I have one, and it's really just out of curiosity because I'm thinking about this since when I read first the draft. How, in your perception, is the relationship between the place of the national supervisory authority or authorities versus what is happening on the EU level? Because my perception is that since the beginning, there is a tendency to have at least more expertise, but probably also more enforcement centralized at the European level at something like the AI office or board or whatever.
It's one of the discussions we need to have because we try to have a more collaborative approach also with the EU and try to get the best out of it. It might be more efficient and more effective to have it centralized. In that case, we of course say yes, keep it centralized for certain aspects. But if it is better for each state to do enforcement besides maybe some difficult cases. So it is a discussion we need to have at a European level, and it isn't answerable.
So it's not entirely clear. Yeah. So we have a final substantive text, but still the enforcement bits and pieces, they need to be worked out.
Yeah.
Okay.
Can I ask him a question?
Yeah, yeah. Okay, go ahead. Yeah.
Could you give a rough estimate of how many full-time people or how many FTE in your organization, the RDI, are working on implementation of the AI Act? Rough.
Yeah, the AI program consists, not full-time, of 15 people.
15?
Yeah.
But some of them not full-time?
Only 3 full-time.
Yeah, okay. So perhaps 5 FTE in total?
Maybe, yeah.
Okay.
Roughly, yeah.
All right. Good. Thank you very much. Also, thank you really for sharing those insights. It's really helpful. It's usually things that I don't know where I would get otherwise except inviting somebody and talking about it. Okay, so we have one more presentation to go. And I'm really curious now, Michael, like you followed the development, of course, of this since the beginning. And I also knew some things that you wrote about it in the past that it seemed to be, at least to me, maybe I misread it, but rather critical. So by now, what would your verdict be? Like, how is the approach? Is it a good approach? Is it a bad approach? Is it better to have a law than none? What do you say?
Cool. Okay, thanks, Oskar. So ultimately, I think we have to look at what type of law the AI Act is. It relates to the title of this panel. The AI Act is modeled primarily after product safety legislation, and that inherently limits the kind of issues it can tackle. The Commission made this choice, and we actually have quite big questions about the legitimacy of the Commission in making this choice. It's not a choice that can be easily, or even potentially, I would say, amended by the Parliament or the Council in later stages. So when that choice was made there, it was set in stone pretty much, take it or leave it. And the approach that's taken is that we crystallize the view of AI as a product or a service. Now, is that what AI is? Certainly in some cases, AI could be considered a product or a service. People can buy AI queries over an API. Now, we don't go to shops anymore and buy big laminated cardboard boxes of Windows 98 software off the wall. It's not quite the same product. You're actually buying something quite different and enmeshing something quite different in your organization. Why this matters is that EU law in the whole, the legal system of this union is quite a different thing, an unusual thing. It is a supreme law compared to member states. And when it decides that it regulates something, an area, it does so and it preempts, it prevents member states from regulating otherwise or in a different way. It decides what kind of thing AI is, and member states now can no longer go and regulate AI as if it was something different than a product or a service. So this is interesting because when we say these are new technologies, I'm not of the opinion that we shouldn't regulate new technologies, but I am of the opinion that we should be careful by locking in the type of way we regulate. Why this matters? When you see small organizations, small businesses, as was the survey was earlier on, of people in the room, businesses are often quite reliant on software providers, not just to obtain software, but also nowadays to frame the way they work. People are organizing their work through services like Office 365 or Notion or Trello or these kind of tools. And businesses become quite plug and play. They don't really become, as they were previously, I think, bureaucracies that sort of start their own culture and people stay for life and they build this kind of idea of how they work. No, instead, actually, software defines the modern workplace and it defines the modern business and it defines the way that they think of their tasks. And AI does this as well. When you've ever been on a call to a call center and faced with automated choices or a system that's clearly trying to get you to hang up the phone and not stay online, it's because AI, not just AI, but software in general, information systems move risk, decision points, and so on around. In that case, they put all of the emphasis on the person on the phone to try and take the risk, to try and use their time, use their effort to solve their own problems, to wait in line rather than have some other approach to their solution. Now, this might seem a bit abstract, but what I'm saying is AI reshifts power in organizations. In fact, it's the main thing it does. AI is intermediaries. We're talking about AI companies who want to get in the middle of value, expensive transactions that happen in the world, whether it's through writing a document or sending some money or analyzing something on the street. Things that we do, companies want to get in the middle and take a slice of value out of that, to reconfigure and to do that at scale. It's the platform business model. You try and do something repeatable at scale with very little overhead, very little marginal cost, and sell it and put yourself in the middle of decisions. And that gives you a lot of power because if you suddenly change what you're doing, you change all of those systems, all of those transactions, all of those interactions at once. So AI is a tool to reshape power around the place. It gives us different points of focus. Now, does the AI Act deal with this? I'd say no, because a product and service puts the focus on the company buying something from a provider. It doesn't look at how that provider accumulates power and makes decisions across society. It doesn't target that specifically. And in fact, it sort of prevents us from targeting it because we don't usually think of products and services as being a way of reshaping value chains as much as maybe something in competition law or other areas which we could have drawn inspiration from, or indeed make a sui generis regime that tries to identify what trajectories and difficult challenges AI will present, and indeed difficulties to innovation itself. Because digitizing your company is not innovation. If you do it wrong, it is taking value out of your company and siloing it and siphoning it off to another provider and leaving you as an appendage at the end of an international supply chain. There are lots of, there are obviously good ways you can digitize, there are good ways you can use technology, but digitization is not innovation and adopting AI is not a good thing. Adopting AI sensibly, knowing your problem, knowing the actual problem you're trying to solve, doing it in a way that's sustainable, doing it in a way that you remain in control and can remain changing your organization in face of needs is important. That is not what major companies AI are selling right now. They are selling something quite different and quite sinister in a way. Sinister to innovation itself. So we're not tackling that with the AI Act because we're seeing it and crystallizing it as a product and a service, a product or a service. And this draws us to the real challenge of the regulatory regime. Who analyzes this technology? We've talked about risk-based regulation at the moment. Well, analyzing the risk itself and then implementing an appropriate response to that risk takes intellectual effort. In the current AI Act, we have an interesting example of how they envisage this to look, which I'll go into. But let's think about who might do that analysis. It might be the user of the system, the business user or the public authority. They might have the pressure, but of course, they don't have very many skills a lot of the time. If you're a small company, you don't really have the ability to understand the full range of human and fundamental rights risks that might be posed. If you're a public authority, you're not going to be necessarily paying very much money, particularly in some parts of Europe, to have that capacity to think about those challenges. You could be the AI provider selling the tool initially. But many of these companies are just rebranding and rebadging tools from much more powerful companies. The AI Act still retains the structure that the majority of the liability is held by the firm that decides to apply a tool for a certain high-risk area. Those companies, they're a bit like liability crumple zones. They don't really have the power. They didn't really train the system. They might not have the expertise. In fact, they're often going to be using drag and drop, simple, off-the-shelf tools to customize a range of tools like GPT-4 or like Google's new Gemini tool that are being sold as a service. They'll integrate these APIs and they'll package them, or an open source model that's online on Hugging Face or GitHub. They'll download them, change them, alter them, put a shiny wrap around them, kind of pretend they're their own thing, and then sell them off. They don't really have the analytic ability either, because they are going to be in a very highly competitive market a lot of the time, where they can't afford necessarily to be too big. And of course, they can be disintermediated at any time by those big companies who might change the way they operate or stop providing their service or good to them in the supply chain. But the AI Act does put most of the emphasis on them. We'll come back to them in a second. Upstream providers. Well, they're like your Microsofts, your Googles. They're context-free. They don't really know if you're deploying it for the police or infrastructure or educational purposes or employment and worker analysis or so on. They try to stay as far away as possible from the application. The last thing they want in their platform business model is friction. They do not want to have to stop and think with every customer, how do I make something that's particularly good for this customer? No, they want something that can be automated, sold, no people have to look at it, contracts are all sorted out, money starts flowing, a computer just whirs in the background and makes use of their IP or trade secret that they don't release to the public, and it makes use of their computational resources they've used to enclose the potential world of their AI systems. So they aren't really getting that. What about external individuals or regulators? Well, we've seen the regulatory regime can be a bit of a mess right now because we've got the cross between horizontal and sectoral. Of course, some regulators are going to be powerful, but we have the whole of Europe to consider here. We have what my colleague Chris Marsden once, in a paper we've been meaning to write up for a while, he branded as the Limassol effect. I think that's because just choosing the second biggest city in a small European state in Cyprus, where it's the opposite of the Brussels effect. You'll move to the place of least regulatory capacity or very limited regulatory capacity. Put something on the door, the regulator itself, the Cypriot regulators are not going to be very big. Regardless of what you think of the quality of each individual person inside them, they are not going to be very big because Cyprus is not very big. And that does not scale for the kind of analysis you might want to do of companies in your door. I mean, let's put Maltese regulators, for example, would be even smaller, obviously. But there's nothing to stop you hosting your virtual AI company with a door plate in Malta at the moment and facing that as the initial regulatory scrutiny. So regulators in this highly informationalized world are not going to be easy to apply their analysis. So what does the AI Act actually propose here? Well, the Commission imagines, like other product safety legislation, that you can ask private standardization bodies to think of rules, standards, quality assurance, mechanisms, processes, all kinds of things that will scale. Get some very clever people in a room, they think, produce a document which is actually copyrighted, you have to pay for to read. And if you do that and you have companies applying this, well, it'll be very easy for them. They won't have to have all this in-house expertise. They won't have to have all this analytic capacity. They won't have to invest. They'll just apply and then sign it off and it'll be good. There's a problem with this, many problems. One of them, these standards bodies are wholly unaccountable. At the moment, they consist largely of industry. They produce private and closed documents that cannot be scrutinized, that are part of European law, actually, the Court of Justice says. They form part of European law, certain standards, when they are mandated by European law. But they do not have the quality of law. These standards bodies are already finalizing a lot of their work on the AI Act right now, before the Act is even passed, meaning that NGOs, civil society, or sectoral organizations that go and knock on the door to try and have input are going to find that most of the decisions have already been made and their input is not welcome. And these standards are not going to be very detailed. They're going to still be slightly elaborate replicas of the kind of things that were written in the AI Act itself. So companies, when applying this, will still have to do a lot of the analytic work and apply choices because this stuff is sectoral, contextual, very fast changing, but also needs some careful thought because you cannot make a generic standard for the use of technology in society. So all of this means that you can't just apply a standard and walk away. Now, that's pretty tricky. I think there's not really a great solution to this within the structure of the AI Act itself. So I'm going to just say one last thing about what will probably happen here. Companies will not be able to apply standards of the Act directly. Standardization bodies will not be able to make standards that are specific enough to do that. So regulators will be forced to do the interpretation. It is passing the ball. The legislators couldn't define something specific because their task was too big and they didn't take the right regulatory approach. Standardization bodies could not narrow it down so that companies could easily apply it. Companies make a lot of arbitrary decisions without any oversight because there's no certification scheme for almost every system in the AI Act. It's mostly self-certification once standardization is created. And then afterwards, regulators who have no capacity will have to make a judgment as to whether this inadequate standard is followed by this inadequate business. And they will have to have a lot of bravery to do so. And that bravery will probably not happen in low-capacity EU member states. It may happen in some, but not in many. And that is probably where we're going to end up. A very difficult to enforce regime, very fuzzy and very hard to get clarity on.
Right, thank you very much. I know that one of our students is from Cyprus, so I hope the Limassol effect was not too heavy for her.
So, individual civic regulators, individual people can be fantastic, but I don't think the student will deny that Cyprus is not a large country.
And we're going to open up the floor, so if you have any questions which you would like to take, then please make yourself known to the students who are walking around. So please just raise your hand. And in the meanwhile, I'd like to ask you, I think that I follow a lot of what you say and I find it very convincing in a way, but at the same time, don't you foresee something like a deterring effect for at least some of the actors because there is a law out there which they could potentially breach? Is it just the big ones who will have the power to find ways to work around that? And is there somehow a gap with smaller and medium-sized companies who will probably then either stop going into this space or like what you labeled also this are they forever going to be caught in this like in-between space where the liability is going to be dumped on them? So I'm just wondering because it seems to be like very much one way there is a regulatory approach, it's not a fitting regulatory approach, there's going to be a lack of enforcement. But the European Commission is going to try to argue exactly the other thing, so that they're saying, but now that we have a law, we will shape the field. You don't see that dimension at all?
Well, I think we'll have to see, but who are the targets of this law? Are you trying to target like real cowboys who are selling systems that are very, very harmful? Well, I don't think they're going to be registering in this database or declaring themselves as high risk. It would be staying under the radar, selling quietly until someone notices they're even there. Yeah. So there are other ways to tackle those kinds of issues. I think if you're trying to ensure that technology that people encounter in day-to-day lives in important situations is actually, is functional and is enforced, and this is, I don't think, the right approach to deal with some of those deeper issues. It does deal with some, and I think you can find big problems in AI systems that you could then hopefully ask the regulator to tackle if they have any capacity. But it doesn't stop the way that companies are going to become effectively reliant on a small number of AI providers to do a lot of this analysis for them, make these decisions, structure the way that people experience the world. None of that is dealt with the AI Act. And furthermore, even the stuff that is dealt with is not going to work very well for the reasons I said across the whole of Europe. And there will be pockets. I'm not saying the Act will do nothing at all. It's also worth noting that the Act is very deregulatory. Like if you read the first recital, unlike what Frederik says, of the Act, it notices, it says, member states cannot regulate AI systems any more than this Act authorizes. Yeah. So any non-high-risk systems, member states are prohibited from making regulation that relates to the deployment or the use of them. And companies who think they've got a low-risk system, like, say, a court using a translation tool, doesn't fall into the high-risk system. Any country trying to regulate that can find that provider knocking on the door of their local court and saying, strike down this law. The EU says you cannot regulate anymore. So this law is primarily deregulatory for a lot of AI systems. Yeah. And I think that's something that is important as a dynamic that is underemphasized.
Yeah, but at least I read from a researcher who is very well known, Cornelia Kutterer, that she cites the Commission saying that if you ask the Commission how much they would like to regulate in the first place, then it's maximum 15% of all the AI applications out there. So I think in that sense I would totally agree that there's this strong notion about deregulation. But just the final point, and then it's really time to open up the floor, so I hope you have some questions. But what I'm then wondering, or what at least I try to be little bit hopeful, is when it comes to things like fundamental rights impact assessments or conformity assessments, which could provide, which at least to me sometimes feel as a place where you can have an interdisciplinary discussion. At least you need to have documented that you did it, where maybe we could go more from a from a space which is very much ex post enforcement, lack of enforcement type of perspective towards a perspective where there's probably a little bit more of a culture change, more like ex ante type of driven?
I think one of the most interesting things in the Act is the database in Article 51, which, or what it will be in the end, final numbering. I'm not sure if all that numbering will stay exactly the same. That stayed in from the final version. And that even means, as far as I read, that a company like Amazon making an internal employee monitoring system, even for their own internal use, has to put it in the database. So even if you're the same as the deployer and the provider are the same organization, there is a lot of transparency options there, and though it's got big, broad carve-outs for law enforcement, migration, and border control, still it's an important route for NGOs, investigative journalists, and other regulators to start to look at what's going on. But I think it comes back to your question of sort of the cowboys or the users of these kind of tools that are maybe doing something that's really heinous. Are they going to engage in this at all? Or will people just say, oh, I didn't think it was high risk, I didn't put it in the database, and we've been using it for a long time. Who's going to surface this stuff? And where are the regulatory priorities if you're going to take a risk regulation approach going to fall? So there are opportunities in this Act, certainly, for other kinds of enforcement and intervention. But I worry that we've crystallized too soon on this product safety approach without thinking about the way that AI will reshape our society. And I don't just mean people will be unemployed and not have work and AI will take their jobs or whatever. I kind of mean who makes decisions about the things that happen around us. That requires a political economy approach, not just imagining that you can do what the European Union loves to do because of the treaties, turn everything into a product so it can regulate it through Article 114 of the TFEU. Yeah. Like, it has to turn it into a product in order to do that in its mental form. It cannot regulate power or fundamental rights directly without basic consensus from all member states. So it takes this other approach, and that is constraining and that is limiting.
Yeah, sure. Might have also to do something with this of European integration. I find it very fascinating, but it's not about me talking. So there we have a question.
Hello.
It's not amplified. It's just recording.
Hello, Stratis Kouyerakis. I'm a PhD candidate at the University of Groningen, and I was wondering on the last remark about the drawbacks of addressing AI as a product. I was wondering if we start to see all the technology regulation of the EU comprehensively, and if we were starting to see whether different pieces of legislation could contemplate each other, such as data protection law and competition law. With such an approach, would you think that we can redress some of those concerns?
Are there any other questions at this point? Right. Yeah, there's another one. I'd just like to collect 2 or 3, and then we just... And I also would like to give Michael a bit of a break because he had...
someone else take that.
So I do research in language technology, and you mentioned that, for example, there's going to be an exception related to profiling people and storing this information about profiling people. But I'm assuming, also from the work that we've been doing for several years, that profiling is also not truly done manually. And I know that... in order to do profiling, you use technology. So I see a little bit of a weird loop there, which is just a tiny example, but that's going to affect everything. Because in order to do that, you'll need AI to do that, and maybe somewhere this will be blocked or accepted. And I actually very much agree with Michael that this kind of restrictions eventually, paired with a whole surge of course, ethical concerns in the research community as well, will halt some healthy developments in AI. So to me, so it is a little bit too constrained, but in a way, like, you always have to find exceptions that will rely on AI tools in order to be addressed. So I don't know how you see this from a legal and regulatory perspective, but
Shall we go with this for the first round? Maybe anyone, any thoughts on overlaps between data protection law, how it also maybe relates to profiling or how this builds into other regimes. You mentioned the Data Act earlier, right? So you also definitely see all of those different types of overlaps.
Yeah.
I can tell a bit about it because
Yeah,
it
sure.
is, I believe, correct that there is a lot of other legislation already in place, and we already regulate that part. And AI is just going into the sector or the part we already regulate. So we already have a lot of legislation in place which we can utilize to regulate AI. It's just that we are not sufficiently aware, perhaps, that it is already there, or that we do not have the appropriate knowledge. It's something we need to develop, and what we see that we are going to develop on. But it is correct that you have the competition law, we have the WBNI, the security legislation, and if the AI comes there, we have an example, for a good example. We have the eIDAS directive of the EU, so an identification legislation. And one party wanted to use AI within the scope of that legislation. We never had AI used there. So how we tackle it? Well, we simply look at the already norms in place, open norms. Is it sufficiently accurate? Is it non-discriminate? Is all kind of people, are they correctly identified? So we already have a lot of in place which we can use and need to use within our already available toolbox.
Yeah, maybe they should have just chosen a more boring name, right? Because if they wouldn't have called it the AI Act, then nobody would have expected that it solves everything, and then nobody would have such stark criticism. I don't know, Frederik, what do you...
So usually I make the most pessimistic and dystopian remarks in any conversation. This time I thought I'm gonna start off more positive, but now I'm back to my usual pessimism. Other laws, yes, actually, we are stuck with it now. But the GDPR, for legal terms, it is still young. I mean, we've been prohibiting murder for thousands of years, and theft as well. And usually what happens is that in case law, in legal decisions by judges, tricky parts in the law are slowly being solved. And actually we didn't have that much time yet for the GDPR to sink in. And for instance, there is a provision in the GDPR about a right to get an explanation about basically AI-driven decisions with far-reaching effects. And now we see case law coming up that that gives that provision some teeth. So in a different scenario, if the AI Act weren't adopted or weren't proposed, we could have waited for more stuff on the ground happening with the GDPR and competition law, and perhaps in different member states. And then the Commission could have looked, in France they had this good idea, in Romania this good idea. Let's learn from the lessons and the mistakes and build something. But this is not the trajectory that was taken, but I'm going to try to say something positive again. Yes, let's hope that that it's not too late yet, but that competition law at some point can limit the power of big tech a bit. About research in AI and not using sensitive data, I was summarizing too quickly. Researchers can often obtain valid consent from the individual involved, but in the example that I gave with job applications, that company cannot obtain valid consent because valid consent under the GDPR must be really voluntary. And if you're applying for a job, you will feel pressured. If I start saying no, then they probably think that I'm a troublemaker. Well, researchers can get fair consent, so that already gives researchers more room. Then also there's a carve-out for researchers in the AI Act. And if I didn't fully understand your question, then I'm happy to discuss more in the break.
Well, for once the law is not running behind, and now everybody of us says, let's take it a bit slower, huh? Yeah. It's also interesting. At least they're heading in the wrong direction. All right, so do we have more questions? Yes, here in the front, in the back, and here. Yeah, we take all three.
Hello, I'm Jurian Paris. working at an NGO called Algorithm Audit, and we're participating in the field of standardization. So next week I will be in Dublin as well to participate in discussions going on about fundamental rights being regulated or standardization activities going on in that matter. And I can just say there are many NGOs represented there. Standards are not finished yet, so I just wanted to take a moment to reflect critically on just that kind of words sent out about standardization world, and especially to reflect on the more ex-ante opportunities that there are under current regulatory approach, rather than the ex-post argument made by Oskar first. So that's my first comment. And the second comment as well on this race to the bottom argument, which was proposed, that we see it with tax law as well. Yep. It's not that all companies are now moved away from the Netherlands. So I think it's a nice narrative to put this EU Act in, but I want to place it as well more into the European frame, how markets can be regulated rather than the Anglo-Saxon approach of self-assessment and self-regulation for 100%.
Okay.
What's that event next week? I didn't hear you correctly.
Well, so GTC 21, it's this Senelec standardization community working on standards. Next week in Dublin, there's like a general plenary meeting.
Yeah, but you're also going to be a speaker on panel 3, so maybe you can tell us a little bit more about that there.
I will do, but just like some like factual
to make the point
to add to discussion.
There was one question here in the front, and then Peter had a question. And if you have one more question, we could also add it, because then we need to wrap it up. Can we just maybe move the mic here? Be very helpful. It's coming, it's coming. Okay. And then we need one more over there for Peter.
Hi.
Hi.
I actually have 2 questions if you have time.
Yeah, sure. Go ahead.
One is for Michael, because you're from the UK. What is your opinion? I can understand all your criticism, and I agree with most of them. So that was very clear. But what is your opinion with regard to the UK approach on regulating AI? Because as far as I understand, they use a very open-ended, neutral approach, which is kind of opposite of the EU AI Act. Whether you can see the same type of criticism in that approach, I'll be very interested to hear. And another question is, as a technology law student, I wanted to know in the North, especially with Bart, that what is the kind of jobs that internationals, when we graduate from a technology law degree, that we can find in the North? Because we were often told by law graduate from this university or from any university is that, oh, if you want a legal job, you have to go to the West. But why can't I stay in the North and contribute to the technology field as an international? Is there more chances with regard to technology, or especially with AI? I know I can't work for regulatory body if I don't speak Dutch, or being a Dutch or EU national, but are there any opportunities? Because we have so many international students, I cannot see the bridge between graduating and finding an actual job, especially in the North. So it would be interesting if you have some suggestion.
All right, great. Thanks for the questions. And one more? Or 2 or 5?
Hi, Peter van Ooyen. I'm researching AI in the UNCG here, so in the healthcare domain. And I've got maybe a couple of questions. I will limit it to 2.
You have 2 minutes for answering. So.
Now, one thing is about the MDR. We already had the MDR, the medical device regulation, enforced upon us not that long ago. That also includes software as a medical device, so AI is also included there. We've got risk categories already defined there. Now we get the AI Act with different risk categories. How do they compare? And how are we which one do we have to follow? Because that's also going to be one of the big questions. Is it going to be MDR or the AI Act? And relating from that, we're doing research in AI in healthcare. More and more of our funding agencies ask us to make something that also can go into clinical practice. The MDR is already making that very difficult. Is the AI Act going to make it even more difficult to go from research to clinical practice with things that we develop in our own hospitals and universities?
Okay, thank you. So who wants to start?
I can take this quickly. Firstly, if we go back to the competition question, just a simple answer, which is I think there's a lack of vision about how these things, I meant the political vision about what kind of digital union we want and what kind of arrangement of actors and power we have, and that means that hinders those areas of law working together. To the standardization point, I still stick by what I said pretty strongly. This is all happening before a mandate, an official mandate, finalized mandate, has ever been issued by the Commission. And this is not legislation yet still, and so this is the point where NGOs will turn afterwards. And I would be very surprised if you would find migration or access to justice or education NGOs in that room, which are all parts of the high-risk areas, and de facto this is a law regulating those spaces because it regulates use of technology in those spaces. So there might be some NGOs from some sectors, but this is a cross-sector area, and those NGOs have not got standardization experience, which you really need to have influence in those domains. And on the medical devices regulation, where an AI system is a safety component or the whole component of a system, it is high risk, but it does not mean that you just have to follow the AI Act. It means that it integrates the requirements into updated standards within the medical devices regulation, and the notified bodies for the medical devices regulation remain the same. So it's effectively a steer on updating areas around AI-specific issues in the medical devices regulation, and therefore feeds fairly fluidly into that. And I understand that doesn't happen immediately. That happens upon commencement I need to look into exactly what point that happens, but it's not that overnight the regime for medical devices actually changes. The point of the regime is that other harmonized regulation, it sort of feeds in as those instruments are being amended and changed and updated as you go. So it's not a difference. It's more like, oh, here's further guidance on AI systems where these guidance applies in the context of medical devices or software.
All right. And so Frederik taking some notes as well?
Yeah, probably Jurian about standards and NGOs can talk more in the next panel. Nevertheless, I point out that it is extremely difficult problem to get some democratic or NGO or civil society input into standards bodies. The United Nations is working on it now, but also sees mostly problems rather than solutions, because even one thing that is open for everybody, like the World Wide Web Consortium. I followed one standard as a PhD candidate. After a few months, I had to throw in the towel. The amount of email traffic is just completely overwhelming, with calls every week in the weirdest time zones. And basically within a few months, within a few weeks, most academics dropped out, and within a few months, most NGOs fell out. So it's really hard to solve. Nevertheless, now that we're stuck with this standardization problem, any influence that NGOs can have is good, of course. I'll leave it at that for now.
Yeah. And Bart, is there something we can do together to bring the international students to you?
Yes, of
Is
course.
this cool?
Well, first of all, the most happy people are living in the northern part of the Netherlands. So, a small thing. But you can always call me, because there are a lot of international companies in the northern part where you can work. For example, in the innovation cluster in Drachten, there are a lot of beautiful companies.
All right. Yeah. We'll keep that conversation going. Well, thank you very much. You will have a well-deserved coffee break. We start again at 2:30 with our second panel. And I hope you enjoyed the discussions. Thank you. Thank you.